So here are some exceptions. We all know about these exceptions, especially this one, spontaneous statement. So obviously, if we're about to bring someone into interrogation and into the interrogation room to be videotaped and so forth, he or she is in handcuffs, and we're walking to the interrogation room and they say, you know what, I killed the person, I did it. Okay, so we can't just throw that out because we didn't get to the room to start recording. So we definitely would use that. So these are the exceptions. I think one of the exceptions is if we interview a person out of state, because it's not Connecticut. So, and if they don't have a state policy or so forth, we can not have to record if it's out of state. Likely we will record. I don't know about video, but we tend to record all the persons that we can record. I think it looks good in court. It's better evidence.
Okay, so is it safe to say, like, is there, because I've never been interrogated. So is there usually certain people that are doing the interrogation and it's pretty consistent? How, help me imagine.
Sure, no problem. Well, I'm glad you've never been interrogated. So it's not, I was a detective.
I have for 5 hours.
So I was a detective for 2 years, and it's not pleasant. I was a sexual assault detective, so the people I had to interview, it was just not pleasant. So generally they're suspects, and anyone can do it. Any police officer is qualified to interview, but we prefer detectives do all that. Because typically this is what happens. This is what used to happen. Cops, might chase somebody with a gun. They get the gun, they put them under arrest. They're heated. The suspect is heated, and then they'll read them their rights, and they'll say, "Yeah, I want an attorney." So now we don't do that. So now we would like that the officers don't read the rights. Just say you're under arrest. You're going to the detective bureau. When you get to the detective bureau, when things calm down and so forth, we'll sit down with you. There'll be video, and then we will read your rights. And at that time, hopefully, people are calm, and generally we're able to get some type of response from a person, because what happens is when you're in soft clothes, people are more, they generally talk to the detectives when they're in soft clothes, and it's almost like, well, the cops are the cops, and even though the detectives are cops, they're in soft clothes. So the suspect generally talks to the detective more so than they would talk to more so than they would talk to the officer. So to answer your question, they're suspects of criminal acts, which is different from an interview. So an interview is someone coming in, they're free to go, and we can just talk to them, and we would read them. Listen, you're free to go. We just want to talk about this incident and so forth. So that is not an interrogation. So interrogation requires you are in custody and we're questioning you. If those two things don't happen, it is not, we don't have to read you your Miranda rights. It's not an interrogation.
Okay, thank you.
And can you repeat what the strategy is behind waiting to read someone their Miranda rights till they get back to, I forgot where you said you take them before you start to question them. Versus when they initially come into custody.
Okay, so if there were a need to question them on scene, we would do that, but we prefer not to. The reasoning is generally when we apprehend someone, and these are unique circumstances, not all the time, but generally emotions are high, and generally it's a uniformed cop who may make the stop, put someone in handcuffs. It may be a heated situation, And if they were to read their Miranda rights, immediately the suspect probably would say, amongst other things, I want my lawyer. But there's no need to, because we're not questioning anyway. But cops used to just say it because maybe they watch too many cop shows too. So, so there was no need for the cop to actually say it. Say, let me read you your Miranda rights, because it requires custody and questioning. So if you don't have those two things, so custody we have them in handcuffs. We don't want to talk to you. Put you in handcuffs. The detectives will speak with you, and that's generally how we go with it. If we said you're in handcuffs and now listen, in the back of the cruiser, I want to talk to you about, did you commit the murder? Now we have a problem. He or she has to read Miranda, but this added statute, the Connecticut general statute, requires it to be taped. So in essence, you have to bring them back to the police department before you read the Miranda rights, because you have to, it has to be videotaped. You can't do it in a cruiser, really. I mean, you could do it with the body cam if it was absolutely necessary, but you always want to interview someone under ideal circumstances. We have techniques and so forth, right? Where you want the person to feel comfortable. You don't want to ask them questions in an environment where they're not comfortable and they're not willing to, they're emotionally charged and so forth. So we'd like to get them into a comfortable position. I think we've seen on TV, which some of that is true. We might give them a sandwich, we might give them a coffee, we might relax them, and then we'll talk about whatever needs to be talked about. When I was a sexual assault detective, I think I got 99% conviction rate because of those techniques. And I would tell the officer, never read the Miranda rights, just handcuff them, tell them the detective will read Miranda rights to you, and it paid off.